If your Queensland Labour Hire Agency has just been served with a non-party disclosure notice, there are 4 things you need to understand before you hand over a single document. First, the procedural distinction. A notice of non-party disclosure under Queensland's civil rules is a specific procedural tool. It requires a much stricter near direct relevance threshold than a standard court subpoena. Not every document the requesting party asks for will actually clear that bar. And that distinction is where your defense begins. Second, immediate protection is available. Serving a formal written objection within the strict 7-day deadline can operate as an automatic stay. That means your agency's obligation to produce the documents is legally suspended the moment that objection is served, buying you the time you need to properly assess the request. Third, and this one is critical, broad compliance carries a secondary exposure risk. Handing over unstructured documents regarding a supplied worker may inadvertently expose your agency to ATO and Fair Work sham contracting scrutiny. The dispute may be between the worker and the host employer, but your classification records and operational data can end up in front of federal regulators. That is a risk that needs to be managed from the outset. Fourth, if production is ultimately required, there is a cost recovery window. Labour hire providers may be able to recover reasonable administrative expenses incurred during document production, provided written notice is issued to the applicant within 1 month of producing those documents. Miss that deadline, and the entitlement is likely gone. If your agency has received one of these notices, take legal advice specific to your circumstances before responding.